My name is Rachel Lawrence. I am a proud 2012 graduate of David Clark School of Law. My title is very long. During the presentation, I'm going to introduce, define resale restrictions, touch on the bigger picture surrounding resale restrictions, including a history of wealth disparity between Black and white citizens with a focus on the district, and how resale restrictions continue this disparity. I'm going to discuss resale restrictions and the law with a focus on the Fair Housing Act, and conclude by recommending resale restrictions are eliminated or restricted to 5 years. Defining resale restrictions. To briefly define resale restrictions, imagine that you make 80% of the area median income, so about $47,000 in 2009 in the district, and you want to buy a home in the city. The city can sell you a home for less than the home's fair market value by making a loan for that amount, and in return you agree to not resell the home for a specific period of time unless it's to somebody who makes the same amount of money as you did when you originally bought the home. So 80% of the fair market, of the area median income. And traditionally this agreement in the district lasts anywhere from 15 to 20 to 30 years or indefinitely. My paper argues that that proponents are mistaken in saying that resale restrictions say that they're doing low-income people a favor, that otherwise they'd be able to buy a home in a nicer neighborhood, because my paper argues that this is no more in favor than any of the favors whites have received with no restrictions attached from slavery through modern times. I'm personally interested in this subject because I bought a home in Northeast DC in 2003 and then promptly worked for a startup company that closed and then worked for a nonprofit in which my position was downsized. Then my first year of law school, I interned with Manna Incorporated, a nonprofit in DC whose mission is to help low and moderate income persons acquire quality housing, build assets for families through homeownership, revitalize distressed neighborhoods, and preserve racial and ethnic diversity. How beautiful is that? And then at Manna, I learned about resale restrictions for the first time. And then in the third year of law school, I took a Race in the Law class taught by UDC's Professor Maukana, who I want to thank because, but for him, I wouldn't be standing here, but also because he's a fantastic teacher. And his class explored a deep and rich perspective regarding the history and current state of race relations. The history of wealth disparity is a look at the benefits and favors whites have received at the expense of blacks, starting with the days of slavery through the modern day. In 1865, just after the Emancipation Proclamation, probably not surprising to know that blacks held only 0.5% of the total worth of the United States, but 135 years later, in 1990, blacks still only held 1% of the total wealth of the United States. The 13th Amendment to the Constitution, which was ratified in 1865, did not address the financial implications of slavery. Economists who try to place a dollar amount on the value of how much whites profited from 200 years of unpaid labor, including interest, begin their estimates at $1 trillion. Jim Crow laws then instituted in the 19th and early 20th centuries, and in many states not overturned until the 1960s, reserved the best jobs, neighborhoods, schools, and hospitals for whites. Federal laws also restricted benefits and protections such as Social Security and unionization through the Wagner Act to jobs primarily held by whites. Under the Federal Housing Administration, of the $120 billion worth of new housing subsidized by the government between 1934 and 1962, less than 2% went to black families. Note that whites did not have any restrictions imposed on these favors or benefits received. This is a slide showing the continuance of the wealth disparity specifically in the District of Columbia. Notice that it's broken down ward by ward. In the wards that are predominantly white, the income is much higher than in the wards that are predominantly black. The wealth disparity, therefore, has not been remedied and continues. A study by Brandeis University in 2010 found that blacks were at least twice as likely, with a specific focus on housing, to receive high-cost home mortgages as whites with similar incomes. The study also found that black mortgage applicants are 60% more likely than whites to be turned down for a loan, even after controlling for employment and financial factors. A United States Census Bureau report stated that 41.7% of the nation's residents grow their wealth through their houses. So, therefore, the Brandeis study shows that the continued discrimination prevents black Americans from growing wealth. A 2002 U.S. Census Bureau report supported this and stated that black households have a lower net worth than white households. We're talking 87,000 compared to 5,000. And a 2009 study by the District of Columbia Fiscal Policy Institute showed that blacks' income between 2000 and 2009 rose only 2%, capping at approximately $39,000, while whites' income rose 20% from $80,000 up into the six-digit figures. Resale restrictions do violate certain legal principles. My paper focuses on multiple cases, but for the purposes of this presentation, I'm just looking at the Fair Housing Act. The Fair Housing Act requires the federal government and all parties involved in federally funded housing to affirmatively further fair housing. The Act also instructs the federal government to take active steps to correct private discrimination, to preclude governmental policies that encourage segregation, and to remedy historical patterns of racially related discrimination and segregation. In general, federal courts have held that the FHA requires only proof of discriminatory effect, such as statistical evidence found with the U.S. Census Bureau. The District of Columbia has held that the FHA should be interpreted expansively, that congressional intent is to promote integrated housing. And according to the census, whites are more likely to be segregated than any other group. As recently as 1993, 86% of whites still chose to live in neighborhoods in which the black population was less than 1%. Therefore, there's an obligation by the District of Columbia, I argue, to adjust resale restrictions based on the following defense. There continues to be a great disparity of wealth stemming from slavery, and resale restrictions support this disparity. Resale restrictions support this disparity because the majority of low and moderate income residents in the city are black, and resale restrictions primarily affect low and moderate income residents. Proponents say that resale restrictions benefit low and moderate income residents because they're a gift and because they wouldn't be able to afford houses in nice neighborhoods otherwise, but this is a myth. For example, there are hidden fees. On top of my previous argument, there are issues with hidden fees in which if you participate in the program and you're living in a condo, your condo fee is not restricted, it can rise. Therefore, your condo fee could exceed your mortgage payment. And if you need to, for whatever reason, move, nobody who's earning 80% of the area median income could afford a house with these excessive condo fees, so you're stuck. Another example is that the average non-restricted homeowner lives in their house for only 5 to 7 years. So resale restrictions in which you can't sell your house for a profit unless you sell it to somebody earning 80% of the EMI is excessive at 15, 20, 30 years or indefinitely. Long-term resale restrictions also are very new in the district. A few states have implemented them: Wisconsin, Massachusetts, California, North Carolina, Texas, and South Carolina. And these states have by and large found that resale restrictions are unpopular, that they are not attractive to purchasers, that in areas in which there is a bounty of affordable housing, they need to lower the resale restriction time to become more attractive to homeowners. In Austin, Texas, when they raised resale restriction times to 15 or 20 years, they were accused of predatory lending, predatory practices. And in South Carolina, town and housing officials were quoted as saying, for a lower income person looking to invest in a home, the idea of not being able to eventually profit was unappealing and unfair. In conclusion, I argue to eliminate or restrict resale restrictions because they continue the history of inequality in the distribution of wealth between white and black individuals from both public and private providers. Further, resale restrictions expose homeowners to risks, including rising condominium fees and possible foreclosure, without providing a reasoned elaboration on why measures are not put into place to address these concerns. Because of this, resale restrictions simply provide the illusion of affordable housing rather than truly providing affordable housing. Under the Fair Housing Act, a city, in receiving federal funds for housing, must affirmatively take strides to closely examine the barriers to equitable and integrated housing, and to the best of its ability, remove these barriers. The district does not appear to have fully examined the issue of race in its affordable housing plans, inasmuch as there is a history of economic disparity between blacks and whites. Proponents of resale restrictions who state that program participants are being provided a gift are particularly in abuse. And while the production of affordable housing is beneficial to end segregation in the city by encouraging low and moderate income, predominantly black residents to be able to live in higher income neighborhoods and wards, the production of affordable housing, while attached to resale restrictions, in and of itself is not enough. The excessiveness of the length of resale restrictions must also be examined, and my paper proposes either eliminating it or restricting it to 5 years or less. Thank you.